Let me in the first instance say good morning to all the teachers and the students, that yes, we are all fighting this deadly disease, this pandemic created by COVID-19. And in the process, yes, we are maintaining social distancing. We are in isolation. There is a lockdown. We are all in our own houses. But at the same time, this is the ingenuity of the human beings, that we are able to find out some ways or the other, because life has to go on. And as far as law schools, or rather educational institutions, are concerned, they have found this system of webinars and holding such meetings and lectures, so that the education should go on. So it is because of this reason, let me tell you, when Sumitra, she talked to me and she wanted, in fact, what had happened last 2, 3 occasions when I was, I'm talking of the earlier period before COVID-19, sent an invitation by the Amity Law School. Normally, whenever I am sent the invitation, I like to come and join, but 2, 3 times, because of my other, busy schedule, I could not make it. So this time when she said, I said, okay, definitely I'll come. And thanks to her, and thanks to the entire Amity community, and Professor Aditya Tomar and Bandyopadhyay as well. Sumitra is no doubt doing a good job by arranging all these kinds of talks. So, of course, today's students, let me come to with this preliminary remarks, let me come to the topic of the today, which I had chosen. It is proportionality and the rule of law. I thought that this may be an interesting topic, because normally you have been studying, most of you must have studied the Constitution and the various aspects of the Constitution. But then, where one part of it, which is applied, one principle in deciding so many cases, that is of proportionality when I come to it, and how it becomes such an important tool for advancing rule of law. So this is what I thought would be really an interesting topic, and it will give you a totally different kind of dimension to our constitution, constitutional values, which is and the basic or the foundation, which is on rule of law, and how we are able to do justice, or how we are able, there's an access to justice to the millions of the people, and the constitutional vision which is stated in our constitution, how we are able to achieve that through the means of proportionality as a principle. So that is going to be the scope of my today's discussion. So I thought that let me concentrate on this kind of topic, so that maybe, I don't know, teachers may have explained you these aspects, may not have explained you the constitutional, those who have taught you the Constitution. So that was the main purpose of choosing this topic for today. Now, you see, the two things which I say in this topic, as I said, that it is proportionality as a tool for advancing rule of law. So the two concepts which are there, one is that of proportionality, and other is that of rule of law. So therefore, since we are talking of proportionality as advancing rule of law, so let us first understand the notion of rule of law. Of course, rule of law is one subject, and maybe in either in jurisprudence or in Constitution, you must have read about that also. Most of the students who are in second year or third year or more, who have read the Constitution. And rule of law itself is a topic on which much can be said. But then, for the purpose of today's topic, since we have to concentrate more on proportionality, I will give I mean, little idea of what we mean by rule of law, and let us capture the essence of this concept of rule of law in that sense. And as you know, it is founded on a very laudable principle or the value, which is this: howsoever high you may be, law is above you. That means any person in a society or in a democracy or a nation which is governed by rule of law, everybody is subjected to law. Whether you are the prime minister of the country or you are a peon in Amity Law School, law is above you. That is what the basic precept of rule of law is. That it is not the rule of men, but it is the rule of law which governs the society. And as we state later, or it may not be necessary to dilate much on that, that it is one of the basic features of the Indian Constitution as held by the Supreme Court in Keshwananda Bharati case and has been repeated in so many other cases. The question is that what are the various features of this rule of law? As I said, that I'll be only flagging the issue of, I mean, the concept of rule of law, would not be able to say in much detail. The basic features of the rule of law is, first, as I would say, absence of arbitrary power on the part of authorities. When I say that law is above you and the authorities which are supposed to exercise the power in a constitution, the constitution is our Grund norm. It is the highest law of the land. And therefore, the constitution is the instrument of governance of the country. There we have, if you know, the three wings of the state or the three pillars of the state is the legislature, which makes the law. At central level, it is parliament. At state level, it is the state legislature. They make the law. Then is the executive, that is the government wing, which executes those laws which are made by the parliament. So executive is formed, or it is the council of ministers and other ministers, etc. In a democratic society where a party which is elected, that is which attains majority, has right to form that government. And they have to execute these laws. So that is the second authority. And third is the judiciary, which enforces these laws. But all the authorities, all three organs, and when we talk of executive, all wings of the authorities come. Council of Ministers is there. There are various ministries. In those ministries, the employees, they are employed, workforce which works, which are called public servant. You know all that. So therefore, everybody in whatever sphere they are functioning, they should not exercise any arbitrary power, and they should act in accordance with the rules of the game. And therefore, the first attribute is absence of arbitrary power. And the second is, which is very important, equality before law. That when we say that law is the governing instrument and the law has to govern, in front of law, everybody is equal. Law treats everybody equally. That is the second attribute. Third is, the constitution is also a part of ordinary law of the land. That is, whatever is stated in the constitution or whatever stated in the other laws which are framed by the parliament or the state legislature, the constitution is also. But at the same time, in the hierarchy of laws, as I said earlier, constitution is the highest form of law. It is called Grundnorm also, it is called apex law also, it is the highest law. And therefore, every law which is framed by the legislature or whether it is state legislature or the parliament, every law has accordance with the principles laid down in the constitution. No law can be framed by the parliament which is in violation of any of the provisions of the constitution. If this is so, if it happens, that law can be challenged. And as I said, enforcer of law is the judiciary. So judiciary has been given the right of judicial review. That is, the judiciary can review whether the law is validly made or not. Of course, the review is on limited grounds. That is, it is not violating any provisions of the constitution. Not that whether a particular law should have been made, should not have been made. To that extent, I'll come when we talk of rule of law. A limited sphere or scope is there, but primarily this, that it was within the power of the parliament and it does not violate any of the provisions of the constitution. But then this is, so therefore, this is the third feature of this. And but then there are, when we talk of rule of law, as I said at the end, these two, but there is a third precepts of the third feature, which I have said that the constitution, that every law has to be in conformity with the constitution. That suppose a law, I mean, that a policy decision, a particular law parliament wants to make, or the state legislature wants to make, that is their wisdom, and that is why these three organs of the state, we call it, they are thrive or they are established on the principles of separation of powers. That no, the function of one cannot be assumed or discharged by the other. The legislature cannot start deciding the cases, which is the function assigned to the judiciary, and judiciary cannot start making the laws, which is assigned to the parliament. So this is what is to be followed. But while exercising this judicial review and coming to a particular law which is made, as I will come to that later in a more detailed form, although this would be a topic of, in recent times, the Supreme Court has said third ground also on which law made by the parliament can be invalidated, which is the law should not be it should not be fraught with excessive arbitrariness, a particular which abhors, which shocks the conscience of the people at large. Now, this is although one norm which is not I mean very definitive norm, and therefore that may be a detailed discussion in this when we talk of rule of law. When you call me, we can talk in detail about rule of law also. But what I'm trying to say here is that, look, normally this is not done because a particular judge may think that no, this law is bad. Another judge may think no, this law is good. So therefore, this kind of discussion could not be given once it is given to the parliament. So that is when we come to the realm of this judicial activism. Start saying that we will be then digressing from the main theme. But then this rule of law had three aspects, which is important, and I will take 2 or 3 minutes in telling that, and then we'll come to the main theme, that is proportionality. One is formal aspect of rule of law. What is the formal aspect of rule of law? That making the law rule instead of men, which I have already explained. That is called the formal aspect of rule of law. Other is jurisprudential or doctrinal aspect of rule of law. And this is very important, and again this may be a subject matter of different discussion on constitutionalism, which again I have given few days ago in some other law school lecture on constitution and constitutionalism. But then when we talk of rule of law and jurisprudential aspect of rule of law, which means although in a democratic society, the government which is elected, the political party which is elected has a right to form the government and a right to govern. But at the same time, in a democracy, it is based on the theory of what we call Thomas Hobbes' theory of social contract. If you know, our constitution starts with the words, we the people. So it is the people who have given the power. We elect the representatives who form the law. And it is for the governance, good governance of the society. That doesn't mean that an elected government, after becoming, assuming the power which is given by the people by electing them, becomes tyrannical. Or the representatives who are the parliamentarian may start making any kind of law. So therefore, that is the second aspect of rule of law, and it is connected with, in a way, morality also. That this aspect of, and which if you have studied, those who have studied the constitution would know, Professor Lon Fuller calls it inner morality of law. Suppose today a law is made, any person who commits theft is a crime, but he will be hanged to death. This is law. And if we go by the formal aspect of rule of law, then anybody committing theft should be given death sentence. But it shocks the conscience. So therefore, this jurisprudential or doctrinal aspect of law, a rule of law says that, look, here we have to treat the human beings who are governed and who have elected their government with respect, with dignity. It should not be tyrannical. After all, if you know, if I give the example, in Germany, Hitler was also, he came to power by in an elected form, but then he became dictator. We know in India the example is of emergency. When Indira Gandhi was, after all, an elected prime minister, her party was elected and she became prime minister in our parliamentary system of democracy. But then, so therefore, this aspect of rule of law takes care of the dignity and freedom of the people. I tell you one thing, then when we talk of constitutionalism, as I am not stating that in detail, but saying it only in the context of rule of law, is that it is based on freedom, liberty, which is most cherished. That is why I use the word dignity. And therefore, this second principle of jurisprudential or doctrinal aspect takes into consideration and guaranteeing fundamental values of morality, justice, human rights, and proper balancing of these rights within the society. So therefore, that is the second aspect of rule of law. And third is, which is called substantive aspect of rule of law. This is the balancing between the individual and the society. This is again very important. Of course, we are talking of human freedoms, we are talking of liberties, but then that doesn't mean that we give liberty to the individuals also to the extent that they misuse the liberty. There is, on the one hand, individual rights, on the other hand, there is a society. So we have to maintain the interest of the society, because the governments, any democratic government has to run for the welfare of the society. So therefore, the societal interests are on one side, the individual interests are on the other side. Both have to be protected. And how balancing is to be made is the third aspect of rule of law. So this is generally the rule of law, which I, in a concise form, I state about this rule of law. And as I said, the topic is how proportionality, doctrine of proportionality, is able to achieve this kind of rule of law, which leads to good governance, which leads to the a society which is more prosperous, as our constitution makers also thought of a country which is economically good, where the people are able to have their bread and butter and able to live a decent life. And that is what the Supreme Court has also said from time to time. So therefore, how now I come to this main theme, how proportionality achieves this. Now, what is proportionality? First, let us understand that. Then only we apply the principles of proportionality. Now, it is, I would say, as the word itself suggests, it is that although there are different meanings given, that as I said, in a democracy or in an elected form of where the elected representatives, the persons who govern, they are given their various rights, even under the constitution, even as per law, to take those actions. Only then the society can function. Now, this law gives them the rights, but at the same time, that should not go in a manner which is excessive in taking a particular decision. Here the doctrine of proportionality comes, that whatever is done, it is proportional to whatever is the impact, whatever is the consequence of an action. It is proportional to the action and reaction, that there is a proportion between that. That is, if I say, when I explain that in real context, you will understand it. Telling you in brief, when a particular administrative or government action or even legislative action, as I've said, is challenged as too invasive, that it is invading into our fundamental rights which are enshrined in the Constitution, the court applies the principles of proportionality and examine as to whether the challenge is proportionate or disproportionate. The action challenge is proportionate or disproportionate. That is, in a nutshell, would be the doctrine of proportionality. Now, you see, I have divided, now when I come to the real aspects of the test, and then you will understand better, they are in three segments, or there are three buckets in which the doctrine of proportionality can be put. One is proportionality in criminal justice system. Other is proportionality in adjudging the administrative action of the government. And third is application of proportionality in dealing with the limitation on a constitutional right or fundamental right, which may go into the legislative aspects. So first, let me talk about the proportionality in the criminal justice system. Now, you know, as far as criminal justice system is concerned, we have Indian Penal Code, which lays down various kinds of offenses which are cannot be committed, and if any such offense is committed and a person is found to have indulged or in that particular crime, then the IPC provides the punishments also. The question is, first question which I ask, are the punishments which are there in the IPC, and there are various other statutes also which may put a particular action as criminal, but we are for the sake of clarity or simplicity, I am talking of only IPC. Now, whether it is as I gave you the example of a theft or it is murder, whether the punishment is same, answer is no. We have section 53 of the IPC, which says punishments to which offenders are liable under the provisions of the code are: first, death; secondly, imprisonment for life; thirdly is omitted; fourthly, imprisonment which is of two descriptions, namely rigorous and simple. You know, some imprisonment are rigorous, some are simple. Fifthly, forfeiture of property; and sixthly, fine. So why punishment ranges from fine, as simple as fine, that you pay, okay, you have done this, you pay 1,000 rupees. Oh, you traffic challans, only punishment in fine. But when it comes to murder, it may be death also. This itself is based on proportionality. That is the seriousness of a particular crime. The traffic violation, obviously, it will appeal to any common sense, cannot be the same as committing a murder or committing a rape or burglary or dacoity, etc., which may be very serious crimes. So therefore, it is proportionality is there, element is attached, that if the more serious the crime, hard is the punishment. And even section 325 of the CRPC gives power to the, if it's a simple crime up to a particular thing, power is with the magistrate. If it becomes a serious crime, the power is with the higher judge, that is the session judge, etc. So that also, in a way, hierarchy is maintained. But then another interesting thing is the doctrine of proportionality. First, I am talking of statutory provision. Is that where that is the second level of proportionality which is stated in the IPC. Although punishment is stated of a particular crime, but it is not. If it is, I say it is say cheating, punishment is not 4 years or 5 years or 2 years or 7 years. That whosoever commits the crime of cheating will be punished for 7 years. Law says up to. So up to 7 years means it can be 1 day and it can be 7 years for the same crime committed by two different persons. Some statutes make minimum sentence and give maximum also. Say if a particular crime says that, look, it will be 7 years but not less than 3 years. So here discretion is with the judge not to give less than 3 years, but at the same time judge can give 3 years also, 7 years also. This, I would say, again is based on proportionality, because same crime, first we were discussing of different crimes where the punishments are different. Here, even for the same crime, punishment may be different, because it may be a case of simple cheating, that one person cheats the other for say 500 rupees, 1000 rupees, and a simple case of cheating, where a particular person cheats, say he forms some organization, tells people to invest your money and I'll give you 20% interest, and in this manner he is able to collect from several thousand persons crores of rupees. Now it is very a serious form of cheating. So therefore the two cases which come to the court, in one case the court may give maybe 1 month or 2 months imprisonment, and in the second case the court may give highest punishment, that is 7 years. So this is again proportionality, which is based on the seriousness of the crime. Now the question is, when this is given by the court, giving in two set of circumstances, and it can be in many cases. I have given the case of cheating. Suppose case of murder. Now whether murder is committed in X case by X murder of Y or by A murder of B, both are murders. Why in one case life imprisonment is given, why in other case death sentence is given? Because minimum sentence is life, so judge can't give less than life. But then in one case life is given, in other case death sentence is given. Again, doctrine of proportionality comes, the gravity of the offense, the manner in which it is committed. And here the discretion which is exercised by the judge, whether in a particular case where the punishment is up to 7 years, I give only 1 day, or I give up to 7 years, or in a murder case, whether I give life imprisonment or I give death punishment, again by case law. Of course, in India, interesting thing is, if we compare it with the United States, in India there are no guidelines prescribed statutorily by any statute or by any administrative guidelines that what should be the punishment. In America, sentencing policy is there, that cheating, first crime, second time, if thereafter also again crime committed, 7 years, third time committed, 20 years. Now the discretion is not with the judge. He'll give 2 years, 7 years, 20 years. But in India, that is not there. At the same time, this is laid down by the courts only, and criteria which is laid down, and we call it in those. Of course, I think most of you must have studied the IPC and CRPC. The sentencing policy which gives discretion to the court, we call it, the court has to see extenuating circumstances and mitigating circumstances. Which are the circumstances which led the person to commit the crime, which were grave, and which are the circumstances which are in his favor, which are mitigating circumstances. Suppose a person commits theft of a bread. At the same time, he is a poor person who was not having his job for last few months. He was hungry for last 10 days, and he is forced to commit the theft. He goes to bakery and he is caught. Whether in such a case also the court will give a very high punishment? No. This is mitigating circumstances, a particular circumstance which has forced him to commit a crime. So there may be in different types of cases, because we are not on sentencing policy, we are on proportionality. But I tell you, this is stated as far as proportionality. There are so many judgments. I will just give the cases in Soman versus Kerala. This is 2013-11 SCC 382. The court has said, while exercising discretion in sentencing, such as proportionality is the first thing said, deterrence and rehabilitation, these are the aspects to be seen. Then in state of MP versus Bablu Nath, this is 2009 to SCC 272, the court says, one of the prime objectives of the criminal law is the imposition of adequate, just, proportionate punishment. Again, word proportionate is used. In another case, Alistair Anthony Prera versus State of Maharashtra, again 2012 to SC 648, the court has said, sentencing is an important task in the matter of crime. One of the prime objectives of criminal law in imposition of an appropriate, adequate, just, and proportionate sentence commensurate with the nature of the gravity of the crime. So the punishment awarded should be Again, in another case, they say punishment awarded should be directly proportionate to the nature of magnitude. I need not say much on that because may not be having much time. So this is how in criminal law the principle of proportionality is introduced. Let me come to the second aspect, which is proportionality under administrative law. Now, I told you it is the executive function of the executive to execute the law, that is the government, which makes the policies, and but all these laws, all these actions are subject to judicial review by the court, and court can exercise the court cannot substitute its decision for that of the decision of the executive, that a particular decision is bad or law, a particular policy is made which is bad or law, good or bad. That cannot be. But at the same time, there are certain, all those who have studied the administrative law, they know that in this, there are many parameters which are used for judicial review of the administrative action. That is, the action should not be mala fide, it should be bona fide action. So if it suffers from arbitrariness and mala fides, then it can be quashed. In taking a particular action, the principles of audi alter partem, that is the person should be heard if something is decided against him, even by the administrative authority, natural justice, which we call. If it is not followed, action can be set aside. In the decision-making process, the considerations which are taken should be relevant consideration. If irrelevant considerations are taken into consideration, it can be set aside. And there are many such things. One of the aspects, again, here is proportionality. Now, how this proportionality in administrative action, even if the particular action is taken by the administrative authorities, is correct, because as I said, judicial review is limited not into the merits of the decision but the decision making process. But suppose decision making process is followed. I give you a simple example. Those who have read labor laws or service law, I gave you one example of service law. Suppose here is a government servant who has committed some misconduct. He came late, or he did, say, cheating, etc., or any such, we call it misconducts which are prescribed under the government rules. Then government authorities can have an inquiry against him, which is called departmental inquiry, and if in the departmental inquiry charge is proved, he can be punished. Various punishments are prescribed, like in IPC I said, under the service rules also punishments are prescribed, which can be fine, which can be say withholding of an increment, which can be demotion from higher promotion post to higher stage to the lower stage, which can be say forfeiture of the increments, which can be dismissal also. Highest punishment is dismissal. But then the court cannot, once they suppose the court has only to see in the departmental inquiry, natural justice principles were followed, and the inquiry was, he was given a fair chance to defend himself. Whether a charge, a material on which the basis the charge is proved, court cannot go into the sufficiency of that material, because court is not sitting as appellate court over the decision of the administrative action. As if you distinguish it from judicial action, if a lower court has taken one decision and it comes in the before the appellate court, first appellate court can go into, under section 96 of the CPC, can go into the entire evidence again and re-examine whether the charge is proved or not, or whether the case is set up by the plaintiff is proved or not. But in departmental inquiries, court cannot go, and court cannot sit as appellate court. It has to see only these aspects which are seen. But another aspect which can be seen is the quantum of punishment. And here, the law which is laid down is that it should not be disproportionate. And what the expression used is, the punishment should not be so disproportionate that it shocks the conscience of the court. Now, again, I give an example that suppose a person who is in the government job, he has 20 years of excellent service. The timing in the morning, he has to reach at 10 o'clock. One day he reaches at 10 past 10, 10 minutes late, and he is dismissed for that. He has committed misconduct by coming late, but for coming this 10 minutes late, can it be dismissed? So the court can say, look, it is grossly disproportionate and it shocks the conscience of the court, and therefore we are setting it aside. And there are various judgments on that, on this disproportionate, and it is not only in the cases of employer-employee that the government servant employees cases only. Suppose many times the government tenders are there. There are contractors who submit their bids, and on the basis of that they can be awarded the contract. Suppose a particular contractor does something which is not as he tries to mislead, give a wrong information in a particular contract, or even if contract is awarded, then he does not fulfill that contract properly and makes default in that, commits breach of that contract, then the provisions are there that he can be blacklisted. Blacklisted means that he will not be allowed to participate in these tender process and can get a tender. Now this blacklisting is maybe for 1 year, 2 years, 5 years, or it may be blacklisting forever. Again, here the principle of proportionality comes. The court, if he has committed some such wrong and he is blacklisted, court will not, and principles of natural justice will follow. Court will not go into whether the blacklisting was good or bad, but whether the misconduct which he had committed or the breach which he had committed, whether that entailed the kind of blacklisting which he was done. Suppose for a very small breach, a person is blacklisted for 5 years or forever, then court can come and say that, look, this is wrong and it should not have been done. There are again various judgments. If you want, I'll give the citations to your teachers and they can circulate that paper of mine on this, because I want to come for the rest of my time the third aspect of the proportionality, which is the most important according to me. This is called proportionality for examining validity of limitation on the fundamental rights. Now, what happens is this, that we are in our constitution, there is a chapter on fundamental rights. All of you know there are various fundamental rights which are granted to the citizens, right from right to equality under Article 14, then Article 15, 16, etc., which are subsets of equality, which says that nobody shall be discriminated on the ground of sex or this either sex or religion or caste, etc., and on employment, in the employment. Then we have the, without stating in detail all this, but then main Article 19, which gives so many freedoms, 7 freedom, 1 now freedom as well as property is not there, other 6 are there. Then Article 21, which says that nobody can be deprived of his life and liberty without process of law. And then rights of minorities are there. Then there's this that nobody will be forced into labor or forced labor, etc. Article 23, which are there. So these are various rights which are given in the Constitution. But then, when I talked of rule of law, I talked of balancing also. Whether on the one hand there's a society, on the other hand there are individual rights. Therefore, all these articles also give power to create exception to these rights. Article 14, although it says right of equality, but this right, we know it has been interpreted, it is not absolute right. And therefore it is based on, if there are 2 persons are differentiated on the based on what we call reasonable classification, which has nexus with the objective sought to be achieved, then that can be validated. Therefore, that is the reason. Otherwise, if it has to be in absolute term, whether he is the managing director in the government body or he is the peon, both should say we should get the same salary. But then if salary is given differently, they are based on reasonable classification, and which is objective, they are performing different kinds of job. qualitatively also and otherwise also. So therefore, this is one simple example I am giving. Likewise, Article 19, one gives all these freedoms, but Article 19, sub Article 2 to Article 6, there are exceptions made that under what circumstances a particular right can be to some extent, uh, I would say, taken away or subjugated in a way. Freedom of speech, Article 19(1)(a) says, but Article 19(2) says that freedom of speech can be curtailed in circumstances in the, if it is in the interest of the state. So that means that I have a right to freedom of speech, but then it should not be that I commit in the process sedition. So that word is used in Article 19(2). Or I cannot take away the freedom of other person. I cannot defame other person. I cannot start abusing other persons because I have a right to freedom of speech. So therefore, if law is made that the provision of defamation is there, which makes it crime, nobody can say that, look, this defamation, this provision is illegal. It is violative of Article 19(1)(a) because I have a freedom of speech. So therefore, now the question is, whenever these rights are there, we have seen the cases and where any law is made and that law is challenged on the ground that it offends a particular freedom or if it offends a particular fundamental right. But the government says that, look, this law is made in the interest of the society to serve a larger purpose, which is permissible in law, as per the constitution itself, while adjudging whether it may be that it serves that purpose. Well, while adjudging whether it serves the purpose, whether the legislature has gone much beyond, here the doctrine of proportionality again comes, which becomes very important to judge the validity of a law, and in the process, it ensures. That is why I started that proportionality as a tool for ensuring rule of law. It, in that sense, ensures rule of law. How? What is this doctrine of proportionality in the constitutional field? That is what now I want to say. Here, whenever first thing which is to be done, what is the first? Let me see. Let me first inquiry which is to be made in such cases by the court when it comes. The first thing is to be determined is the scope of constitutional right. The court will first see what is the scope of constitutional right, whether this particular right which is claimed by the petitioner is a constitutional right, is a fundamental right or not. I give you simple example. These are some of the cases which I said are clear cases of example. But sometimes an issue arises whether a particular right is fundamental right at all or not. And example is right to privacy. It is nowhere mentioned in the Constitution. So therefore, there was such a debate whether right to privacy, and there was a judgment in the beginning given by the Supreme Court, right to privacy is not a fundamental right. Another judgment came, and so many judgment came, it is fundamental right. But because of this conflict, matter had to go to 9 judges bench in Puttaswamy case, that and ultimately held right to privacy is a fundamental right. So therefore, the first issue is when a right is claimed, whether it is a constitutional right at all or not, the court will go into that. So once it is determined it is a fundamental right, then naturally it is guaranteed right in the Constitution. So the petitioner has that right which is called as fundamental right. Now the action of the legislative action, second question would be that limitation which is there, whether that limitation is limiting that particular fundamental right. Now, if it is limiting that fundamental right, that means the right to that extent is getting violated. But question is, mere violation is not necessary if it comes within the scope of Article 19, 2, 3, etc. as I said. So if the second is also that yes, the action of the legislature is limiting that fundamental right, then the third question would be whether such an any action, suppose first I say any action, then the third question would be, because any if you see any fundamental right which is given to the citizens cannot be curbed except by law. So it can't be by administrative action. So it must be backed by law. So that is the third thing, whether there is a sanction of law. And the fourth thing which the courts have said while adjudging the this constitutionality of such a provision, here we come, which is the topic, whether this limitation is proportionate. That law is right is eclipsed, but whether it is proportionate, whether this much of eclipse was required or not. If it is disproportionate, the court can say that this kind of was not necessary. It is, as I said, is a rule or principle of limited government, which we call negative constitutionalism also, that to uphold the rule of law, the legislature should not go far and beyond of what is necessary, only to that minimum extent. So therefore, the inquiry can be on proportionality as well. So therefore, now in deciding whether it is proportionate or disproportionate or not, that is the fourth thing which I have said, how the court applies that principle. First is the purpose for which that restriction is imposed is a proper purpose. If the purpose is improper, the court can strike down that. Secondly, the measure taken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. That is what Article 14, in a way, that classification which says. Third is the measure undertaken are necessary in that there are no alternative measures that may similarly achieve the purpose. That legislature or the government before the court will have to say, look, we have taken this particular step because there is no other step which is possible. And this was the only measure which was possible. So absolute necessity of taking that measure. And the fourth is there needs to be a proper relation. That is, here we call proper relation in stricto sensu, that is balancing between the importance of achieving that purpose and social importance of preventing that limitation. This is what we call balancing. So the court will undertake this exercise in full. And that is what actually this doctrine of proportionality, of course, as I may tell you, I gave many citations earlier under the criminal law, under the administrative law, where the word proportionality is used. But the doctrine of proportionality in detail in judgment was not stated earlier. Recent judgments, the courts have propounded on that, and in a great measure. The first judgment in which it was stated was Modern Dental College and Research Center versus State of Madhya Pradesh. It was that NEET judgment, not first NEET judgment where NEET was set aside. The second NEET judgment where it was restored in 2016, and incidentally, I was the part of that constitution bench who wrote that judgment, and I propounded this theory of proportionality and how law is to be judged in the terms of this proportionality. And what I am saying today is much of that is said in that. Thereafter, it had been explained in detail in Puttaswamy case, Puttaswamy 1, which is a 9-judge judgment. And there, it is a very interesting thing in, let me see, because the principles which I have stated are very easy, but their application to the given facts of the case may become very, very difficult. Now, how balancing is to be done? In Puttaswamy case, 9 judges, almost all 9 had given, 5 or 6 had written their opinions, where Justice Chandrachud, he formulated the test of legitimate state interest. That the limitation which is imposed, the government, Union of India, will have to show that there was a legitimate state interest in imposing that. Right? They were discussing of right to privacy. If right to privacy is to be curtailed, it should be in the legitimate state interest. That it should be. Then Justice Talmeshwar and Justice Sapre used the expression that it should be, the test should be compelling state interest. It should not be only legitimate, very, very compelling, a very high threshold. And Justice Kaul talked of if it is public interest, in public interest, that is sufficient. And Justice Nariman, on the other hand, use the expression, it should be in larger public interest. So the four expressions are used in that judgment: legitimate state interest, compelling state interest, public interest, and larger public interest. But then after, because that was the judgment which in Puttaswamy 1, where they only answered whether the right to privacy is a fundamental right or not, and laying down this, the matter came. And the Puttaswamy 2, in which the case was decided, there the majority decided to adopt the principle laid down by Justice Chandrachud of legitimate state interest, because it was of majority opinion. So therefore, while balancing, we have to see the legitimate state interest. And in Puttaswamy 2, everybody knows it's a Aadhaar judgment. Although majority, I am saying, although majority upheld Aadhaar scheme, but many provisions of that act were set aside and declared unconstitutional only on the ground that they do not fulfill the test of proportionality. That this kind of restraint, a particular kind of restraint given by that particular judgment, because that again I would say Aadhaar is, first of all, I am almost running out of time, and secondly, Aadhaar judgment itself is a judgment which has laid down Puttaswamy 1 and Puttaswamy, that there can be complete discourse on that, on this judgment only. But in nutshell, if I say, on that basis, like giving it in private hands, that banks, etc., and all Aadhaar, we said that look, it is privacy is given in the private hand, which is not permissible. And then saying that even for everything where it is not even necessary, because under the Aadhaar Act, the main reason was that the money under the welfare schemes should go to poor persons. That doesn't mean that for opening a bank account also, for even a person has to cremate a dead body, for that also you have to show Aadhaar. We said that sorry, it is going too far, and it is not in, in that sense, it doesn't subserve the legitimate state interest. And the other principle which I said, that no other measure is possible. We said sorry, there are many other measures which are possible which can be achieved by this, and therefore those were set aside. So how it was, proportionality test was introduced and balanced both ways, generally accepting Aadhaar as valid, but at the same time hiving off all those provisions which were offending this principle of proportionality. So this is how I say the judiciary is able to restore the balance and restore the rule of law, and in order to ensure that the concept of limited government and the governments should not impinge the fundamental rights of the people by any other mean, and therefore doctrine of or the tool of proportionality, it becomes a very handy tool. Thank you very much.
Sir, police in India is a state subject, but when we have different political parties in powers in different states, then they try to define rule of law by use of police according to their whims and fancies. Is it feasible for a democracy like India?
You see, this is more a political question than a constitution. Of course, it has the facet of constitutionalism also, there is no doubt about it. As I said, in our constitutional scheme, separation of powers is there. Yes. Separation of powers means one will not trample into the powers which are assigned by the Constitution. And insofar as the 7th schedule in the Constitution is concerned, it has 3 lists. And in these 3 lists give the subject matter on which the law can be made. And Article 73 of the Constitution very clearly says, as far as the executive power is concerned, executive power is also commensurate with the legislative power. So therefore, if there is no legislative power, there is no executive power also. And list 1 gives the subjects which on which the parliament can legislate. List 2 gives the subject on which the state legislature can. And list 3 is of course a concurrent list which yes. both can do it, subject to Article 245 and 246, that one law should not be repugnant to the other, and that is taken care of by Article 245, 246. But then even the Parliament has no power to legislate, and the union government has no power to act something which is within the domain of. So therefore, the question here is that yes, the police is the state subject. To that extent, you may be right, but then there are some ways and means by which, like at the same time, we have CRP, Central Reserve Force, we have CISF also, and we have CBI, which are, of course, CBI constitutional validity thereof is pending in the Supreme Court. And if you remember, students remember, the Guwahati High Court has already declared it unconstitutional. But then through these means, and sometimes when it comes to that, the situation, law and order situation is there, which is not limited to a particular thing, which is not limited to a particular state only. It has pan-India ramifications. So under the guise of these things, legitimately or otherwise, many times a particular, in particular situation, state government try to act in a particular state also. Yes, in individual case, it would be known whether such an action was within the jurisdiction of the central government, or it impinged upon the powers of the state government. That can be a matter of adjudication in a particular case.
Absolutely, sir. Sir, the rule of law talks about individual liberty, that is, judge made laws through a judicial precedent related to a particular case. Is the court bound to follow same law in the preceding case with significant relevant facts?
No, you see, this is talking about doctrine of precedents,
Yes,
or
sir.
what we call stare decisis also.
Yes, sir.
Normally in common law system, which we have inherited from Britishers, and common law system is very much prevalent in this country, and it is applied day in and day out. This is a very important principle of following the precedents, is which is, as I said, based on the doctrine of stare decisis, and the main objective behind it is to have certainty. Not that one judge decides a particular case in one way, and the other judge in a similar circumstances is taking another decision. So therefore, the second judge should follow the earlier judge if some decision, a binding, because all this is that it should be a binding precedent. Now, how binding precedent is there? That there's again a plethora of case law and plethora of literature. What is the meaning of precedent? That means we have to take out a ratio of a case. We call it ratio descendi and obiter dicta in a case. Law students would understand that. So finding the ratio of a case, it is only that ratio of a case which will be binding, not obiter. But obiter is which was just like by side, some observations were made by a judge in a particular case. So, and any norm, any principle which was laid down in that judgment. Second is that yes, the judgment should be what is the judgment binding? We have Article 141 of the Constitution. Article 141 of the Constitution says that any judgment of the Supreme Court is the law of the land. So therefore, that judgment becomes the law of the land, and that is binding on all the courts, all the high courts and the subordinate courts, and even the coordinate benches of the Supreme Court. Now, and likewise, the judgment of the High Court, a particular, suppose Delhi High Court has given a judgment, is binding on the entire Delhi High Court judiciary. It may not be binding to Bombay High Court, but here it is. At the same time, if one and the judgment within the same court, judgment of a larger bench is binding on the smaller bench. If in the Supreme Court three judges had decided one particular case, it is binding on two judges. And it is binding on even coordinate bench, that is three judges. But at the same time, one judgment of three judge bench and another judgment of three judge bench, they can differ with that. But while differing, they cannot say the earlier judgment was wrong, unless it is, in our legal terms, what we call per incurium. And again, what is per incurium is a matter of detailed discussion. I can't go into that. And but then in that case, the three judges will refer the matter to larger bench, that is five judges, which will decide whether one coordinate bench was right or the other coordinate bench was right. So this is the scheme under which normally the precedents are binding.
Honorable Sir, traditionally, impact of offense is considered for judging the proportionality. However, in criminal law, as you have mentioned, both mitigating factors and impact are considered while imposing punishment. Sir, how proportionality and mitigating factors are interconnected, or whether mitigating factors are exceptions to proportionality?
No. They are, I think they are interconnected. Not in that sense. That is the exception. Mitigating factor, it becomes itself in the sentencing process a facet of proportionality.
Facet of proportionality.
So it becomes a facet of proportionality when we go into the proportionality under given circumstances. When the crime was committed, what were the reasons? As I gave you the example of a person stealing a loaf of bread when he was hungry for 10 days. Now, I give you another example, which is a very interesting, again, good example. Suppose some terrorist is there and he wants to kill one highly, placed person in the government, very senior, in a very senior position. I come to know of it. It is some function is going on, and that person is giving a speech. I come to know of that in this X is the person who is there with the gun. He is a terrorist, and I don't have time to tell the police, etc. He's about to kill him. I also have a revolver, and I kill that terrorist so that he is not able to kill. Now I have done something which is really good for the nation, but I have committed the crime of murder. I have taken the law in my hands. In a case like this, when I am tried by the court of law, I have committed murder. Judge has no judge can because minimum punishment is the life imprisonment. I may be given life imprisonment, but that is why here when the sentencing policy discretion is given to the executive. In such cases, there have been such cases in the history. While imposing the punishment, judge will tell the executive, the president of India, to set him free because he had done for good cause.
Yes, sir.
So therefore, this is mitigating factor which comes as a facet of proportionality.
Sir, another two related question. If the judgment is disproportional by giving a very harsh punishment for a simple crime, won't it create a powerful precedence which will create a sense of fear amongst common citizens, which will in turn reduce future crimes?
You see, again, this question is on sentencing policy. I tell you, I have touched only the cases which I read. Some of the cases I touched the aspect of proportionality. But then here we go into the jurisprudence of punishment, of theories of punishment. Why punishments are, why a person who commits a crime in the society is punished for whatever. This punishment may be fine, as I said, it may be jail for some time, different periods, it may be death penalty. There are 3 or 4 theories. One is deterrent, which this question is asking.
That's right, sir.
That the person who has committed the crime should be punished, because if he is not punished, then it will not act as deterrent to the rest of the society and everybody will start committing crime. And that is why deterrent is one reason. Other reason is, theory is this is deterrent, other is reformatory. Reformatory is that person should be punished and sent to jail for some time so that during that period he is reformed. That is why we have now the modern jails don't talk of only that if it is 7 years imprisonment, for 7 years you do, if rigorous imprisonment, you do only labor, manual labor. But there are so many activities which go on, and the students also nowadays reads and they become a part of it. How if that particular criminal should be reformed then during that 7 year, and there are so many activities in jail. There are vipassanas also, yogas also, vocational trainings are given in the jails. It is for reformation. The third is retribution. Retribution theory is that deterrent is deterrent to the society. Retribution is a person who has committed the crime should be punished because the victims of that crime, if it is a grievous hurt, the person who is hurt, if it is a murder, his family members should feel that yes, justice has been done. If you know the recent case that this 16/12 December,
Sir, there is what is proportional difference between culpable homicide and murder? Both abstract and practical concepts.
you see, this is a question purely, I need not, it will be a great, detailed discussion. It's a question basically of IPC. But a very interesting question in another way, that this again, I would say it's a good example which I can give now in future in my lectures if I give on this subject, that culpable homicide amounting to murder and culpable homicide not amounting to murder are having two different punishments, and I would say it's a classic example of proportionality again, because culpable homicide amounting to murder is of higher magnitude and not amounting in both the cases person has been murdered, in both the cases person has been killed, but law recognizes one as a crime of murder, doesn't recognize as crime of murder in other case, and it is because of the intensity and the circumstances under which these provisions are there.
How do you feel like these days, because we see that a lot of benches are transferring the matters, or maybe not transferring the matters, but taking the matters into the inquiry commissions. The inquiry commissions are being involved. Maybe it was Ram Janambhoomi case, or maybe it was CGI's sexual harassment case. Inquiry commissions were held. So how do you propose that these inquiry commissions play a role in advancement of rule of law, as well as whether proportionality also comes there somewhere, which these inquiry commissions, any role of inquiry commission?
You see, one thing is there, Mr. Arora, and you know, as a teacher also, and as a academician and as a publisher, you know much more about these things. I would look into why normally it is done. If you see, what is the difference between a writ petition which is filed in the High Court or the Supreme Court, or a civil suit which goes before the either district court, or in Delhi we have the High Court also has the original jurisdiction. Now, in a suit where the two parties are saying something, different parties are naturally they take different, and there may be dispute on facts, there may be dispute on law. Insofar as dispute on law is concerned, the law and who is right and who is wrong. How the disputed facts are to be decided? Disputed facts are to be decided in a suit by evidence. So parties come, they lead their evidence, respective evidence, documentary as well as oral evidence. And on that basis, the court comes to the conclusion who is saying right, who is saying wrong. This is in the criminal cases also, when a particular crime is committed or not, evidence is produced to show crime is by the prosecution, crime is committed. But when it is a writ petition, where no evidence is led, a writ petition is decided only on the basis of affidavits. And the writ petitions, of course, documents are there. So sometimes there may not be much issue on facts. And even there are some issues on facts, they depend upon the interpretation of those documents which are there. The court can say who is right, who is wrong. The interpretation of these documents suggests this. But when there are questions of facts which are complex, which cannot be decided without evidence, in writ petition, so therefore, one of the ways which is devised nowadays, as you know, normal rule is that, okay, either the parties are relegated to the civil suits so that evidence is led and who is right or wrong. But these are the cases which are touching the human rights or fundamental rights of a person also. So it is not proper for the court to just relegate the persons to civil remedies. So therefore, in order to find out where the truth lies and where are the facts correct, commission of inquiries are sometimes, these are adopted. That is what I will look at.